Hello, my name is Craig Call. I'm the Executive Director of the Utah Land Use Institute, and we're pleased to bring you a seminar today on exactions and the details that surround the exaction of land or improvements or funds at sometimes imposed on development, so that development in part pays some of the burden imposed by growth. This program is part of a series sponsored by the Division of Housing and Community Development in the Utah Department of Workforce Services, and we certainly appreciate their funding that has brought this opportunity to the state. We also appreciate the Office of the Property Rights Ombudsman in the Department of Commerce. Their land use training funds are used to help provide the online land use library, where the conversation today will be posted more or less permanently as long as it's relevant. But we appreciate the ombudsman and they're doing that. We also appreciate our direct funder, the S.J. and Jesse E. Quinney Foundation, a long-standing supporter of the Land Use Institute. There are materials prepared for this segment of our discussion on exactions. They are available online right now, whether you're watching this live or later streaming. Go to utahlanduse.org. That's utahlanduse.org, and then click the workshops page, and there you'll see the topic that you are viewing, and you can bring the materials online in front of you. They are available permanently for downloading, and we hope they will be of great value. They are well prepared by Mr. Smith in this case, and it will be a great resource to you, because it'll quote chapter and verse on exactly where the authority is for the discussion he's having. If you have any questions while you watch the video, I'm happy to respond to them. info@utahlanduse.org will work permanently. So as you watch this at whatever time you do, please feel free to contact for comments or questions. We appreciate suggestions, improvements, and corrections at info@utahlanduse.org. With that said, let's turn the time over to Craig. He's a very talented and prolific litigator in the land use arena. He's handled some of the most prominent cases we've enjoyed reading in Utah, and are delighted to have him with us here this morning. Please, Craig, proceed.
Great. Thank you, Craig, for that kind introduction. Main areas that I consider myself to have some competency in are land use and water law. And what I'm going to talk about today is kind of an intersection of both those areas of law. And so it should be, for me, it's fun because it's two things I'm interested in. And what I'm going to talk about is dedications and exactions for development. Now, water is one of those things. We'll talk about other things that can be required to be dedicated and exacted. But first of all, I'm going to share my screen here, which hopefully I will be able to do. Yeah, hopefully that's come up. I think it has. So, and I probably need to change my thing so it's just a slideshow, not showing the other things on my browser. So I can get that done. Be ready to go here. So, whoops, that's the wrong thing. Shows my lack of technical abilities here, so I better go back to what I was doing. Let's see. Anyway, hopefully I'll be able to get this straightened around here. Thank you. I got some help here. Okay, now we're ready to go. So we're going to talk about dedications, exactions for development. So it's very common to have a requirement when you're developing land with houses or whatever to be required to make some dedications or exactions. People say, well, what are dedications and exactions, and what, how do they work? Well, and is there a difference? So first of all, there's no difference between a dedication and exaction. It in the statutes, they're typically referred to as exactions because they're exacting things from a private property owner or developer and requiring them as part of to do that. Dedications are when you look at the other side, well, they're dedicating to a city or to a county or to whoever they're having to dedicate to. So, whether you call them dedications, that's why I kind of call them dedications / exactions in my paper, because it's really both. It's really both those things. And a lot of it's just your perspective of that. So, dedication or exactions, that's one of the first things we're going to, what is that? Let me go to my next slide. And, there's kind of a definition. It's, when they public district, municipality district, or other public water supplier, or, land use authority, I should say as well, require that you dedicate water shares or land or even money can be done. Now, one thing I'm going to steer away from in making this presentation is we're not talking about, we have another presenter who's going to do an excellent job on impact fees. And in Utah, that's, we kind of have a pretty good distinction. Impact fees are governed by Title 11, Chapter 36 of the Utah Code, a whole chapter of the Utah Code on impact fees. And so anytime it's money, it's typically going to fall under an impact fee and fall under those rules. Now, we do have rules for dedication and exactions, but they're not as robust as they are for impact fees. But if it's, typically, well, you're getting, even though a dedication exaction can be a monetary dedication exaction, if it is in Utah, you typically will, like I say, then you're going to be under the impact fee statutes, that chapter, and you're going to have to follow those rules. So that's something to remember as we go forward. So we're going to typically talk about land, water, perhaps other things, other material things that can be required to, and that you're required to do development. So obviously it's not, I'm wanting to donate my land, I want to donate my water to the city, but it's, what are you required to do? And there are limits on it. Let's talk about the kind of the roots of dedication exaction law that go that are found in the Utah and United States Constitution. And those roots are based on the takings clause, the clause that's in the Constitution: no private property, nor shall private property be taken for public use without just compensation. It's the same constitutional provision that covers eminent domain. If the city wants your property, they have to buy it, or the state or federal government, whoever, they have to give you just compensation. Now, typically in exaction dedication, they're not paying you for this. And so then the question is, well, how much can they require you to provide? What kind of an exaction can you be required to do without going over, that becoming a taking? I mean, what are the limits? And that's what people always want to know. Whether you're a city or a county or a district or a private property owner or developer, whoever, you want to know what those constitutional limits are. And so, since these are constitutional limits in the United States Constitution, unlike a lot of areas of land use law, this has grown out of the law has really been developed by the United States Supreme Court. And it took a long time to do that. I mean, we had cases that were almost a decade apart. And there are 3 cases that we're going to talk about. And you can see that I've got those up on here. And one was done in 1987, the other one 1994, and the other one 2013. Now, 2 of the cases that kind of are the most important cases have sort of similar names. One is Nolan versus California Coastal Commission, and the other one is Dolan versus City of Tigard. Tigard's, by the way, is a city up in Oregon. It's a suburb of Portland. And so, and Nolan obviously took place in California because that's who he sued. So we're going to kind of talk about those cases for a few minutes because they really set the basis for the limits and requirements of dedication and exactions in Utah law, and have since been codified in our Utah statutes, as we'll also talk about. So let's talk about Nolan first. That's the first case that came up in 1987. So it was Mr. and Mrs. Nolan actually owned a beach house in a very desirable area. It was about an hour or so north, an hour or two north of Los Angeles. And at one time, I think it was actually during this litigation, Patrick Nolan, who was one of the named plaintiffs, actually was an assistant city attorney for the city of Los Angeles. And so he obviously worked for a city, but maybe that's kind of what inspired him to challenge this. So in California, they have a statewide coastal commission, which regulates development along the coast, as you would expect. And you have to get a permit from the coastal commission before you can do anything really to your property on the coast, or you can develop it or rebuild it. What Mr. Nolan and Mrs. Nolan wanted to do is they wanted to rebuild the beach house. And you can see on our PowerPoint, we have a before and after. They wanted the beach house they had was one of those, back in the funky times of maybe 30s or 40s or 50s, and people had, beach shacks, and obviously wasn't very big, wasn't very fancy. And they wanted, they actually had been damaged by some storm. And so they decided they just wanted to rebuild it. And you can see what they ended up with in the after picture we have here. And then also, so that was what they wanted to do. They went to the California Coastal Commission to get that permission to do that, so they could do that. And the Coastal Commission came back with a condition that they thought was improper and wrong and illegal and unconstitutional, however you want to say it. That condition was there was actually, and you can see in one of the pictures, there was actually a private beach in front of the Nolan beach shack, or whatever you wanted to call it from before, where they owned the beach and they could exclude other people from using that beach. Now, obviously, if it was, if you're how familiar people are with how that law works, obviously, if you stay below the high tide, you could walk by it, but you couldn't, set up your chair and umbrella and enjoy that beach. And so that was the condition that Nolan's pushed back on, was the condition of having to give an public easement to their beach and making it a public beach. And you can understand, I think anybody could understand, if you were so lucky as to have a private beach, you wouldn't want to be deeding that privacy away. So that ended up in the United States Supreme Court. It went through, state court, I think went to the California Supreme Court. United States Supreme Court, obviously, they take up cases where they want to enunciate some area of the law. They're not so concerned about Mr. Nolan and Mrs. Nolan in their beach house, but they enunciate the law. And so this gave the Supreme Court of the United States a chance to enunciate on this area of law. And in that case, what they looked at was, and the test that was employed by the Supreme Court was, okay, what is the nexus, or what is the connection between what Mr. and Mrs. Nolan want to do, build a new beach house, and what is being exacted, a public easement. And the Supreme Court could not find that there was a real connection between those two things. Basically how the Supreme Court looked at it was, there just isn't that nexus. I mean, nothing about what Nolans are doing would be addressed by, impacts of a bigger beach house are not addressed by making the beach public. That's just, that's basically the California Coastal Commission trying to get something that it wants and trying to use this as an opportunity, this permit as an opportunity to get something it wants that's independent of what the Nolans are trying to do. And so they struck down this requirement. As you can see, he got the beach house built. And it's interesting, I think it was just earlier this year that Mr. Nolan passed away, and there was some some things in the media about that because of this case has been kind of a famous case. And so that created what we look at as the first prong or first part or first element, however you want to say it, of the what we now call the Nolan-Dolan test. And that Nolan part is, okay, there has to be some connection, whatever the impact is going to be of the development, there's got to, this, whatever you're exacting has to address, there has to be a connection between those things. It's addressing that impact. I mean, you think about, well, what would it, maybe it would have been parking or something. I don't know. There are things that, may have been impacted by the bigger beach house, but it certainly wasn't, any connection between that and the public beach. And so that created the first prong of our test. And then as the Supreme Court does, they only decide cases in front of them. And it was a number of years before the next case came along that gave us the second prong. And that's the Dolan part of the case. Dolan is the Dolan rough proportionality requirement. So we already know there's got to be a connection or a nexus or something between both the impact caused by the development and what's being exacted. In Dolan, they addressed the second part of the test, but let's talk about Dolan for a little bit. So as I mentioned, Tigard is a suburb of Portland. I actually had a nephew who lived there for a while and had a chance to go to Tigard. It's a nice suburb of Portland. And the Dolans had a hardware store. And you can see on the PowerPoint, there's a picture of their hardware store. And what the Dolans want to do was to expand their hardware store. And the town of Tigard came up with a number of things that they required, that they wanted the Dolans to do: bike path, more parking, and there were a number of things that were part of the, these are the things that the exactions that were going to take place for you to develop the hardware store. And again, this case made it again to the United States Supreme Court. Supreme Court looked at it and they added another element to the now Nolan-Dolan test, which is not only does it have to be connected to it, because most of the things that they wanted, the town of Tigard was exacting, were connected. Like the bike path, so that people maybe could access and not have to drive a car to go to their store. Additional parking due to the fact that the store was going to be bigger, the hardware store. But what the court focused on in that case was whether there was a proportion. What was the proportionality? What was being exacted based on what was the impact? So not only then had to be connected, it had to be what the United States Supreme Court decided. It had to become roughly proportionate, and that's a term of art, rough proportionality. And sometimes I get asked by people if what that is, what is roughly proportionate. And again, there's probably no one answer to that, but so and when you look at proportionality, okay, how much? So if someone's going to build 10 houses, let's move it to the water context. So someone's going to build 10 houses. How much water is going to be needed for those 10 houses? How much are those new residents going to use? And if you exact enough water for 20 houses, that's probably not going to be roughly proportioned. When you talk about more about water exactions, and the same thing with other things as far as land or anything else you're exacting, you have to have that proportionality. Is 1.5 times roughly proportioned? I would say not. I think 1.5 is clearly not. I think is 1.25 the times, is that roughly? Well, that's probably getting closer. If it's 1.5 times versus if it's 1.1 times, that's probably roughly proportionate. You don't have to be exact. The term roughly is used on purpose here, and the purpose is that you don't have to get exact, but it's got to be in the same ballpark. I think 1.5 times you'd have a hard time arguing that that's in the same ballpark, but I think it was like 1.2 times what it turned out to be the exaction and the impact. Then you probably are within roughly proportion, and then there's a fuzzy line somewhere in there. So you don't have to be exact, but you have to be roughly proportioned. So then we have now our two-part test, the Nolan-Dolan roughly proportionate. I'm sorry, I said that wrong. The Nolan-Dolan test, which is there has to be a connection or nexus between the impact and what's being exacted, and then there has to be that exaction has to be roughly proportionate to that impact. So that brings us now, I'm going to go to the next case, the Kuntz versus St. John's Management District. It's not, it's not as important, but it was again another United States Supreme Court case, came, a decade and a half or so later. And in that case, they looked at what things that could be exactions, and they said, well, money can be an exaction. In that case, the issue was dedication of land was the question. There were some wetlands, not surprisingly, this is in Florida, is where the St. John's Water Management District was. And when they weren't water managing to get more water, they were dealing with, swamps and wetlands and, handling water that way. And in that case, they applied. That's when the Supreme Court applied applied the Nolan-Dolan test, and also had some other things, including whether the amount of acres that the water district there was trying to exact were correct. And so that gives us the basis of Utah law on exactions. None of this came about in Utah, but again, it gave us that basis. And so I'm going to talk a few minutes on that basis. And so I'm talking about how the law developed in Utah on exactions and dedications. And I'm going to talk about a few of the cases. Unlike some areas, we haven't had a lot of recent cases, but I think we will be having some in the near future. But kind of the seminal first case on exactions and dedications. Now, this predates even the time when we had the statutory provisions as to impact fees. But what we have, this case is Call versus West Jordan, and this case was actually cited by the United States Supreme Court when they were addressing the Nolan case. They actually cited to this Call versus West Jordan case because there was these 7 factors. Again, these are kind of also worked their way into our existing statutory law. And you can see the factors that the court looked at to say whether an exaction was proper, was cost of and this is, again, more a precursor also to the impact fee law, and you can find elements of this in our impact fee law. But it was talking about, again, this was really kind of addressing sort of the proportionality of it, what it is, extraordinary costs, kinds of things, because, and most of this, again, is now addressing impact fees, but it still has some bearing on the exactions and dedication case law we have. Talk about a couple of other cases just quickly, so we don't run out of time here. We have the Banbury decision, and then that Banbury, there was, even when Banbury came to some about whether you could, whether you even could do that. And so this Utah Supreme Court held that constitutional standards of reasonableness govern the validity and amount of subdivision exactions and impact fees. So they came up with this idea, well, it's got to, you can do it as long as it's reasonable. And that came out of the Banbury case. And then there's a number of cases, and I'm not going to spend much time on these, that came after Banbury: Lafferty versus Payson City, Whitener versus Linden, and these all help to kind of flush out various areas of both what now is in the impact fee statute, but also in the statute to cover exactions, and help flesh those out. Really interesting cases is what I call the BAM trilogy. There were 3 cases involving BAM versus Salt Lake County. I think if they had been tried in a different way, we might have some different case law from that, because I think BAM had a very, very good point. BAM was an acronym for a developer, was building a development in unincorporated Salt Lake County, and the county was requiring him to dedicate land for 13 additional feet. He'd already agreed to dedicate 40 feet for the dedication for the 35th South, the wide 35th South. They said, no, that's not enough. We want another 13. And he challenged that. And the reason I think that could have come out differently is that that was a state road. 35th South, for some reason, is a state highway. County really had no reason to exact anything for it because it wasn't their road. And we now have some statutes that address some of that a little bit, but that was the kind of the interesting thing about the BAM trilogy and the analysis that we get from that. And so, you know, we have all this. So this is kind of our Supreme Court, Utah and federal Supreme Court background for this, these things that came out. And then what that led to is, and when my slide here, I probably need to change it. When I say 2023, these statutes all preceded 2023. These statutes were, though, amended in 2023, and we're going to talk about the amendments that were made in 2023. But so where we ended up with in Utah is we now have 3 statutes that govern exactions, specifically for water interest, but also for some other things. And we have the one is for municipalities, that's in 10.9A, 508. And if you do land use law, you'll recognize, you know, what chapter 9A is. That's the enabling act for land use by cities. Same thing with counties, county exaction statutes. It's in 1727A, that, and it's in, you know, one section different, but that's again is the county land use management. You know, it's the LUDMA, however you want to say it, Land Use Development Management Act that governs and empowers the land use regulations by cities and counties. The third one, even though I call it a county one, it's because these districts are typically under the county. It's one for special districts, and that's found in 17B. That's the what we used to call local districts. That's now special. Legislature changed the name to special districts, not to be confused with special service districts, which are another type of district that are under direct control of the counties, where I think the county statute, the statute governing counties would apply. This is for the more independent special districts, and these all address different again. And what this legislature did, they didn't go out and try to redo the law. When these statutes were drawn, they drew upon, when they were drawn up, they drew upon Nolan Dolan, and that's right in the statute. We'll get to that in a second. You know, they codified the Nolan Dolan analysis and other aspects of Utah law that we, you know, kind of just quickly talked about. And they codified those in the statute, so they are found in the code sections. You don't have to go back and argue case law or go back to argue, you know, constitutionality. Obviously, that underpins all this. The underpinning is the Constitution for all this, but that's what you have. So now, it's, you know, with those statutes in place, and I've got full copies of those in the materials. So you have a full copy. They're just one section each. I've got full copies of those and more stuff that I can talk about in the materials. Now that we have these statutes, and not understand we have these rules, then the question arises. And in recent years, the question that's been most pressing, at least in my practice, what I've seen is water exactions. It's very common for annexations or even developments within a city in Utah, or within a district, or, you know, that if you want to develop, you need to dedicate water rights or water shares to the local government, to the city, or to the district that's providing the water service. And that's become kind of a hot area in recent years for a couple different reasons. One reason is, yes, we are a very dry state, and water is precious, it's valuable. Supreme Court has likened it to a drop of water being a drop of liquid gold. It's not quite that valuable, but you get the idea. And I think we all are kind of a little more cognizant or recognize this because of, you know, things that have been happening recently with the Great Salt Lake and its shrinkage, and I think steps have been taken to try to reverse that. And also on a bigger scale, the Colorado River Basin in Utah is obviously part of that, and what's been happening with the Colorado River and dividing up the water in the Colorado River. And so So that's become a hotter issue. Now, one of the reasons that's the other factor. So first of all, now we understand water's value. Water's important. You need to have water to develop. A lot of cities don't have the water to do it. But now that helps us kind of adopt, find out where we are now, because there's been some recent action. So for many years, I'm going to talk about what I'll call the 0.45 acre foot indoor domestic use requirement. So little background on that. So for many years, for most of my practice until recent 10 years or so, it was a standard in Utah that for each house, a typical, residential house in Utah, that throughout the year that they would use approximately 0.45 acre feet of water for their indoor domestic use. Now, 0.45 acre feet, an acre foot is 1 acre of land covered by 1 foot of water. It's like 351,000 gallons. But acre feet is the common way we measure not flow, but of quantity of water. And how that 0.45 had come about is there is a rule in the Division of Drinking Water Standards that that rule says that you must have 400, on average, 400 gallons a day for each residence. And you take 400 gallons a day, you times it by 365 to get you a year, and then you come up with and convert it to acre feet. It comes out to almost exactly 0.45 acre feet. So that's where this standard came from. Well, beginning in 2009, and I've listed some of the studies here, there started to be studies that questioned the 0.45. Even though it was, and when I say it's a regulation, it wasn't a water right regulation by the Division of Drinking Water. It's a source and storage regulation. They were telling people you need to have a source being a well, spring, lake, wherever the source of your water is, and storage, your tanks, whatever that can handle, that you can serve on average 400 gallons a day to all the residents in your city, district, whatever. So in 2009, Division of Water Resources, and that's another division of the state of Utah. It's not the water rights that regulate water. It's the big picture water planning and stuff. They released a study, and I've got studies in my materials. I've also got a link to where it shows you where you can find that. And what they found out that average use, and they did this for 24 cities in Utah, and this is just indoor use. This is not outdoor irrigation. They got the water meter records from those cities, did the calculations, and figured out that, rather than 400 gallons a day, the average person was using about 182, the average house, I should say, 182 gallons a day. And if you convert that to acre feet, that's 0.20. And that was an interesting finding, because that's a lot less than the 0.45 that you found pretty much everywhere, as far as what you had to dedicate or was exacted from you when you developed the land. Then there were some follow-up studies, there's 2 legislative audits, and you can see the results of those there. All of these studies were well below 0.45 as far as water use per a residence. And you can find those as well. And, I've got the citations where you can find in them. Then we have a state of Utah water use data collection program report where they got a lot of data. So it became pretty clear that 0.45 was, no, I don't need that slide. 0.45 is, let me back up here. I'm going to take it off of the, I think I've gone through all my slides. It became pretty clear that, I can find my sharing here. I'll quit sharing that. But anyway, it became pretty clear that 0.45 wasn't the right amount. And so there was, for lots of different reasons, there was reluctance to Division of Drinking Water change its standards. So in 2018, the legislature got involved after they'd had these two audits and they've seen these studies. And how the legislature got involved is they made a change to the Safe Drinking Act. So the Safe Drinking Act is found in Title 19, the Utah Safe Drinking Title 19, Chapter 4 of the Utah Code. And that's the, kind of what empowers the Division of Drinking Water and the things they do and how they regulate things. And they added a new section to that section, I think it's 114. That new section required that over time that individual systems from largest down to 500 or more had 500 more connections. There was a timetable for these systems to create their own system-wide rather than a statewide standard for how much water was needed for source and storage, which ties in, and I'll talk about that in a minute, to the exaction of water. They had to come up with their own system-wide standard based on their own numbers. And there were some deadlines in that legislation, in that code. And the first ones were supposed to be done in 2019 for the bigger ones. And then the smaller ones was supposed to be done by this year, where what was supposed to happen, and has happened, not as uniformly as you would think. What was supposed to happen is the water districts, the cities, whoever was the running and owning the water system was required to submit 3 years of data to the state of Utah as far as their water use. And based on that, the Division of Drinking Water would then come up with a system standard for source and storage, which was, kind of an interesting thing. And so some places needed to be prodded to do it, but that's been happening. And guess what's happened? Well, when that's happened, we've seen the standard go down. We've seen the standard go from 0.45, for example. I'll give you a couple of cities. One is Tooele City, a place that's always kind of short on water. They had a 0.45 standard. They had it since 1998, and then like 3 years ago, they after they got the study done, they changed their standard to 0.25 acre feet for indoor use. And Saratoga Springs is another city. Again, they had the 0.45, and everybody kind of thought that was a safe harbor. It really wasn't. But and now they're at 0.3, and so we're seeing this change around the state, reducing the amount of water that's being exacted because of these changes. Now, the second wave of this is going to be even a little bit more interesting, because in those statutes that we just talked about that limit on exaction, one of the things is they require that if you're going to exact water as a city or a water district, if you're going to exact water rights, water shares, whatever, from people who want to develop, you have to show that you do not have sufficient water already in hand, or you own sufficient water rights, water shares, whatever, to be able to serve that development. So, for example, Salt Lake City does not exact water shares or water rights when somebody develops, because Salt Lake City has a very large stock, and being that one of the oldest cities, has a lot of water rights and a lot of water shares. But you have to be able to show that, and that you have this need for water. And you say, well, how do you show that, or how's that done? And you look at it in a planning horizon of 40 years, and this ties into some other legislation that wasn't related to exactions and dedications, that allows cities, public water suppliers, cities, districts, whoever can meet the definition of public water supplier, they're able to stockpile water rights and water shares for their future needs up to 40 years. And they're required to do, if they want to do that, they're required to file what's called a 40-year plan with the Division of Water Rights that shows what their needs are now and project them out 40 years. And if you're going to have a deficit in 40 years, then you can exact water rights and water shares. If you're not going to have a deficit in that 40-year planning horizon, you cannot exact water rights and water shares. And kind of where the second kind of step of this that hasn't quite all sunk in yet is a lot of these 40-year water plans have been done on the standard of 0.45 acre feet for indoor use. And obviously, when that changes, the water plan needs to change, and you're going to have more water that's going to project out. You're going to be able to have more units, or ERCs, equivalent residential connections, is what the Division of Drinking Water comment. You're going to be able to have a more ERCs based on your new standard that's going to be lower than 0.45. And if it's 0.25, you can see how many more units that could supply. And so far, I haven't seen much action, interest, whatever, in looking into that second part of this equation. Is okay, well, your study says you're going to run out in 25 years based on 0.45, but if we change that to 0.25, when are you going to run out of water? It's going to be 20 years, 40 years, 50. And if it's after 40, then state law says you can't exact. You can't require me to dedicate any water rights. So that's an interesting thing. And again, as most things in water do, these things kind of unfold slowly over the years. Now, there was still a lot of unrest and unhappiness in the development community, particularly in the multifamily development community, about the, and what they were unhappy about is, well, even if it's 0.25, that's a one size fits all. I mean, that's for a house. What about for my apartment? I'm building, and I'm going to only have 2 bedrooms in the apartment, and these are the fixture counts and things. Yeah, this one size fits all doesn't seem correct. So in 2023, at our last legislative session, and that's why I put 2023 by all those statutes that are in the materials, there were some changes made to the law that takes us away from, and those statutes takes us away from the one size fits all. Now they have to kind of take consideration of the type of housing that it is. So if it's a single family house, that's maybe one standard. If it's a townhouse, maybe that's another standard, smaller. If it's an apartment, you can see where, based on the water use of those types of dwellings, that you may have to have 3 standards or 4 standards for dedications or exactions, instead of just that single standard of 0.30 or 0.25 or whatever it is for single family homes. And again, that's a new law that just came into effect just in May of this year. And again, we're not seeing immediate changes on that, but I think we're going to see some changes on that. Because that's what the law says you have to do. So that's an important recent change. Another thing that's important is they also, by that, in each of those statutes, tied the water dedications more directly to this source and storage. These were probably always somewhat tied together, but now it's explicitly tied together that your water dedications requirements are tied to, again, how much water each person uses. And now we're tying that, because of the changes in the law, to actual real data, not, a statewide 200 or 400 or 500 gallons a day. That's another important change in the law. The last area I'll talk about, because I'm nearly out of time here, of exactions and dedications, that's I think still kind of, these are the cutting edge frontiers, is okay, what about outdoor use? Now, because all the numbers we've been talking about, the 0.45, 0.25, those all talk about just indoor use. They don't talk about, well, what if I have particularly if I'm building single family homes and they're going to have yards, what about that? And what's interesting about that is there's a couple things. So that, again, a little bit of water law background. So we have what in Utah was what's called a duty for water, the concept of duty, and that's the amount of water you can use for a particular use without wasting the water. And for irrigation, which is the most common duty, because still most of our water is used for irrigation, is determined by how many acre feet per year of water are needed to grow alfalfa. That's the bellwether crop. And so we have varied duties throughout the state. And in my materials, I have a copy of the duty map that you can look at. We have varied duties, varied in the appendix, I should say, uh, duties that range from 3 acre-feet per acre up in Camas or Cache Valley, up in the higher elevations, colder areas, shorter growing season, more rain in the summer, up to 6 in hotter areas like around St. George, Washington County, and some other places where you have a longer growing season for remember, alfalfa is a crop. Well, I shouldn't say remember, because most of us don't probably know, but alfalfa is a crop that will grow throughout the entire growing season. You hear about hay cuttings. Well, yeah, in some places you get 2 cuttings. Some places you can get 3 cuttings of hay. That's because even after you cut it, it continues to grow. It grows throughout the whole growing season. It doesn't die off in the winter. I think, people typically replant their alfalfa about every 6 years, but those years have, and so it's a long growing crop. And then the other thing that these duty values are based on, or duty amounts, I should say, is also based on traditional flood irrigation practices. When I say flood irrigation, that means water's in a ditch, it goes down furrows, and you have furrows in your field, it goes down those furrows, and that's how you irrigate. Well, that's how you used to irrigate, because hardly anybody does that anymore. It's not a very effective way to irrigate. Even farmers have sprinklers, and of course, nobody at their home has furrows in their lawn. And so we have that that's going on, that maybe those duty numbers are high. But again, when you come to outdoor use, most places, again, like they were using the 0.45, most cities, most water districts, most counties that they're adopting, and many counties have on a countywide basis what the water dedication requirements are or water needs are for the unincorporated county. They're using the duty number, which is probably a high number for the reasons I just talked about. And again, no one has really dug into that very much that I'm aware of. Maybe somebody has, and there may be questioning about these outdoor water dedications. The other powers, things we have happening that are affecting this, again, come from the outside, and that outside is water conservation. This past session of the legislature, Utah passed a law that provided $5 million to pay people to get rid of their turf, to get rid of their grass. They're going to, there's a program now to pay people to take out lawn. Why? Because we're trying to conserve water. Again, so does that, and again, that kind of ties into, and also there we have, even more effective and efficient water systems such as drip irrigation. So if you look at the typical ordinance or policy or whatever you have, for the city, county, district, whatever, what they've typically done is said, okay, we're going to use the duty number, that's 3, 4, 5, whatever it is, 6, wherever you are, as to how much water, and then we're going to figure out the amount of land being irrigated. Is we're going to just look at the subdivision plat, and we're going to take out the streets, take out the housing driveways and house locations, and everything else we're going to consider as being irrigable. And that's how we're going to do that. Well, now we even have, in addition to for conservation, take out your lawn, people are being encouraged to do zero-scaping or other sorts of things that don't need any sort of outside irrigation or water. And this puts, I do represent, I've sort of talked about Exactions a little bit from the developer standpoint. We represent a lot of cities and a lot of water districts here, and that can put the city or the water district into a little bit of a funny situation, because the developer comes, and what if the developer says, we're going to have all zero-scape lots, and so I shouldn't have to dedicate any water for outdoor use, or I'm going to limit, we're going to have something that limits people, they're going to have limited areas where they can irrigate outside their homes. Well, that's all fine and dandy, but when the developer sells out the subdivision, he's gone, she's gone, whoever the developer is gone, and it's up to the residents then to make the rules and do whatever. And unless there's some way that those rules can be enforced as far as limiting outside watering by the city, by the county, by the district, they could get in a situation where, developer's gone, people say, I really don't like this zero-scaping. Let's, even if they have it in their CC&Rs, let's change it. let's let people irrigate if they want to. It's a free country. People should be able to water lawns if they want to. And you could have people who, you know, it goes from a xeriscaped or minimally landscaped development to a highly landscaped one because people want to have lawns and enjoy their lawns. Everybody has a lawn, right? I have a lawn. Everybody likes their lawn. And people want to do more watering. So you got to look out for that. So again, we're going to see more changes in that area. Those are the areas I think for water dedications where we're going to see the most change. Otherwise, we're going to probably stick with what, again, the Nolan Dolan test that's been authorized by statute, and it's also in the Constitution. And you know, right now it's just how much. You know, it's not. Is there an impact? Yeah, I mean, does a new house create an impact on the water needs on the water system of the city? Yes. Well, how much of an impact is that going to be? How much needs to be dedicated and exacted? So my materials cover pretty much everything better than I have done verbally here. I don't have my PowerPoint loaded up, but I will get that loaded up on the website, but my materials are. And happy to, I don't know if there's any questions or anything. I haven't really looked for that. If there's any questions, try to answer those, or if not, then my time's up and we'll go on to somebody that's probably going to do a much better job and give you a better insight on the areas they're talking about. Thank you.
Thank you, Craig. We appreciate this extended discussion and particularly your expertise with water exactions. And we'll feature that as we load this video onto the website. Let me also thank Scott Ellsworth, who was part of the discussion. You know, he was one of those who got us going in the beginning with this plan, and Craig's helped out and finished the work, but we certainly want to mention Scott as we
I can never say too much about how much Scott helps me. Scott's he's a great writer, and he is the co-author, and the reason people can read my writing as well as they can is because of Scott.
Thank you. Looks like we have a comment from a viewer. I have your hand up, but I don't see the duty numbers. Are those then would be in the PowerPoint rather than in the handout, which would be on the same web page?
Oh, somebody said they didn't have the. It should be a question about the duty numbers. There should be a map in, you know, and
the map is there, I believe, but the duty numbers may not be.
Yeah, we'll get that fixed to make sure we get those on there so that people have that. If not, you can go to the website of the Division of Water Rights and they have a map that shows the duty numbers around the state. Okay. One thing that they can't, one thing that's not explainable is why the duty in Salt Lake is 5 acre-feet per acre, and in Utah County it's 4, and in Ogden it's 4. That has something to do with ancient politics. It's not because people use that much more water in Salt Lake. So,
okay. Well, again, thanks. We appreciate that. And thanks to those who viewed and will view this online. If you have additional questions or comments at any time in the future, use our access at info@utahlanduse.org. That's info@utahlanduse.org. Thank you.